fundamental principle is not in dispute, and it should guide this Court's interpretation of the statutory scheme. This Court should not depart from this well-established principle. Instead, it should interpret the statutes consistent with the goal of a for-cause recall system. And that goal is surely to permit the removal from office only of individuals who really should not be in positions of power, not just anyone who is less than ideal or favored by the view of a particular group of sponsors. I'd like to start by briefly discussing three foundational elements of Alaska's for-cause recall system. And those are that the statement of grounds must stand on its own. Secondly, that the statement must be factually particular and legally sufficient. And third, that the statutory criteria cannot be so broadly interpreted that every official can be subject to recall, because that is in effect a purely political recall system. After talking about those three specific sort of general concepts, I'm going to talk about the specific allegations in the Recall Dunleavy campaign's statement of grounds and why they fail to meet the requirements of the statute. So going to the first central element of Alaska's system, that is the idea that the statement of grounds is the only message or the only medium by which the committee gets to make its arguments for recall to the initial group of voters, but also, most importantly, to the division for review and to this Court. That statement of grounds has to be 200 words, and it must describe the grounds for recall in particular, 200 words only. Those words cannot be supplemented by extraneous facts or by citing other documents that contain additional facts. The statement has to communicate to the reader the reasons why the official should be recalled, because that is what those words in the statute mean, that the statement must describe the grounds for recall in particular in not more than 200 words.
Ms. Peyton Walsh?
Yes, Your Honor.
I beg your pardon for interrupting. This is Justice Stowers. I am curious about the argument that you've made in your briefing just a moment ago that it's somehow impermissible within the 200-word context for a recall committee to make references, to reference statutes, to reference other materials. Why do you say that, and where in the law would we find that prohibition?
So I think, to be clear, we're not saying that the committee can't reference the statute. The idea is essentially that you can't circumvent the 200-word limit by simply citing a document that has additional words and additional factual explanation. So, and I think the most fundamental way that you can see that that's not permitted by the statutory scheme is that the statutory scheme is set up in balance. The committee gets 200 words, the official gets 200 words. And if you can essentially just skirt that by citing a longer document in your statement, then that word limit doesn't have any real meaning. And I think it's also important to remember that what gets posted in the polling place and the statement that's attached to the petitions that voters sign, that's just the 200 words. It's not that whatever else might be in something that you've cited. And so the statutory scheme is set up in balance to allow the reader of the statement to should understand as fully as possible what the committee's reasons for recall are. And if you can't understand those reasons without reference to material outside, then that statement isn't doing the job that the statute clearly intended. So I think that that limitation is inherent in the statutory scheme.
Ms. Peyton Walsh, this is Susan Carney in Fairbanks.
Yes, Your Honor.
Isn't there another element of balance, too, that we have to take into account, in that 200 words is not an awful lot of words? Doesn't that need to be balanced against the level of particularity that can be achieved in only 200 words?
Well, so I think that the problem with that is that you can't give the official making the rebuttal that same leeway that you're thinking about giving to the committee based on the 200 words, right? So the official is responding, they have 200 words only, and that's all they get. And they're not getting the leeway of the court allowing them to kind of assume some kind of knowledge that you're talking about giving to the committee. And what we're looking at here is with a for-cause recall system, the official does have a due process protected interest in their position. Now, they don't get a lot of process here. They just get what the statutes give them, but that's supposed to be an equal amount of time and space to make their case. And if you give the committee leeway that you can't give to the official, you have destroyed that balance in the statutory scheme, and that creates a due process problem, we think. But I also think that there's another sort of problem with allowing outside material to come in, and that is sort of what sort of principle do we have for drawing a line about what the division could consider or what a court could consider in addition to the 200 words. The committee has talked a lot about how the campaigns are going to fill in the gaps, and people understand what this is about because the campaign has told them, or there's been a lot of publicity. But we don't know that voters necessarily have read the same news stories that the committee has. We don't know what people have looked at and seen. And when the division gets that application, all it gets is that 200-word statement. It doesn't get a bunch of newspaper articles. It doesn't get all of those things. It doesn't have any idea what the scope of that extra material that it might consider. The only principled line in this scheme is the four corners of the statement.
So one of the arguments that the parties have made in reference to one of our cases is that one of the overriding purposes of this 200-word statement is to give fair notice to the official who is sought to be recalled, an understanding of what the charges are, if you will, what the complaint is. Your client has also argued it's important that enough information be given so that the director of the Division of Elections and then ultimately the voters can also understand what is the factual basis for the charge. And as I look at the petition here and the references that were cited, apart from the constitutional references and the statutory references, which you concede are appropriate, there's this one reference, it's essentially a footnote, that says OMB change record detail, appellate courts, university, AHFC, Medicaid services. Doesn't the addition of this reference accomplish all three of the purposes? It gives the official who sought to be recalled an understanding of the factual basis under charge number 4 regarding this allegedly mistaken veto of approximately $18 million. It also gives the division and ultimately the voters who choose to take a look at this document an understanding of the factual basis. Doesn't adding these references actually advance the purposes?
So I don't think so, Your Honor, because I think there are a couple of problems, I think, with your sort of conceptualizing of how this would work. So first of all, some voters may go and may be able to look up what an OMB change record detail is and determine more information about the vetoes that were being referred to. But that doesn't necessarily tell them what it is they're supposed to be looking for in terms of what the significance of that additional information is. But more than that, voters are not many voters won't ever see that. Any voter who doesn't independently go and look up that information is not going to have it. And I think that makes the statement should be an explanation to the voter and to the division and to the court of why the official is going to be recalled. And if you need to go and look something else up somewhere, you're not providing that information to the reader.
But then doesn't that argument apply equally to a citation of a constitutional article or an Alaska statute?
So the reason that I don't think there's a problem for the committee to cite those statutes. I don't think it's necessary, though. I mean, this court found in Miners that an application did not need to identify the laws that were violated, only to provide a sort of a factually sufficient explanation of the conduct that constituted the violation. So that, you know, a layperson who isn't familiar with the language of the Constitution or the statute might feel, for example, that an official who stole state money to take their office on a party or something had done something wrong without being able to cite the statute. And as long as the person can describe the conduct that's wrong, we're not going to expect them to identify the law that's been violated. So we don't have the fact that the committee provided citations is essentially sort of irrelevant, I would have said, rather than, I don't think it helps them, right? That language, that additional information isn't necessary, but it's also not, it doesn't need to be there. So I don't think that it serves a purpose that we care about.
Counsel.
In terms of what the statute requires.
Counsel, this is Justice Eastaugh. I'm wondering if you could tell me whether it's your position, in particular with regard to the mistaken veto allegation, that as described, this ground does not give the recall target enough information to respond.
So I think that allegation is perhaps one of the more specific allegations. I think the problem with it is that the committee has argued that it is alleging not just the ground of incompetence, which is the word that's used in the statement, but also the additional statutory grounds of neglect of duty and lack of fitness. And I think that for the purposes of those statutory grounds, there isn't enough information in the language of that paragraph to explain their theories, because their theories are essentially either he didn't understand the budget process and that means that he's incompetent, or he wasn't intelligent enough or careful enough, and that means that he's not fit. And all of that's a lot of those are additional factual allegations, for one thing, and also a lot of sort of explanation that is I think an essential part of tying the factual statement, there was a mistaken veto, to the ground. Because I think that the statutory scheme requires some sort of explanation, not just for a set of facts to be thrown out and to hang there while people try to figure out why this particular allegation constitutes neglect of duty or lack of fitness.
Counsel, this is Justice Mawson, and I have a question about that. Is your argument that the committee has to know or at least make an assertion about the governor's state of mind when he makes a veto, like is alleged in the fourth ground for recall? It has to know whether it was incompetent or unfit. It has to make that allegation. And I'm just thinking about circumstances where they may not know.
Ms. Payton-Walsh, hang on just a second.
Yeah.
Justice Mawson was not finished with his question.
Well, I think you know where I'm going with that. It's just that the people who are formulating the recall petition might not necessarily know what was in the governor's mind when he took this action, and they may want to put it out there as either lack of fitness or neglect of duty or maybe incompetence, depending on what was in the governor's mind when he did it.
Well, and I think that a committee could allege in the alternative, but I think it has to do so specifically. It can't just say, here's an allegation, here are 3 grounds, and then expect the official to respond to each of those potential theories that the official has to try to figure out without the explanation in the statement, and then the official has to respond in his or her 200 words. And that's not the balanced system that the statutory scheme contemplates.
Well, so I guess I'm not sure that I see that in the statutory scheme. I mean, if if there are three voters out there, there's voter A, voter B, voter C, and voter A thinks this particular action demonstrated a lack of fitness, and voter B thinks that it demonstrated incompetence, and voter C thinks that it demonstrated a neglect of duty, all three of them are voting consistent with the statutory grounds for recall, but you're saying that only one of them is right.
No, actually, I think what I'm saying is that the balance in the statutory scheme requires some level of fairness to the official. And if you have three voters who could each have three different interpretations, the official, in order to successfully rebut, has to deal with each of those three allegations in his 200 words. And the committee has essentially taken an advantage by being vague. Their vagueness is essentially a way to require the official to do much more with his or her limited space than the committee has been required to do. And our position is that the committee should be required to be specific enough, because it's not, otherwise we don't have that statutory balance that's baked into the system.
Counsel, I have a question for you. This is Justice Winfrey in Fairbanks. And it kind of goes to all of these questions that you've been answering so far. And I'm going back and looking at the language of the statute. In 1545-500 talks about the form of the application, and that's where you get the language about the grounds for recall needing to be described in particular and not more than 200 words. But in 1545-550, which gives the bases for denial of the certification by the division, it says that the application is not substantially in the required form. Now, as I look at that, and it goes on to say, of course, there's some numbers have to be, the dates and number of people, et cetera. And it seems to me that this is essentially saying that the sponsors only have to substantially comply. And the only thing that could be, seems to me to be subject to substantial compliance would be this particularity requirement. Is 1545-551 about substantially? Is that a substantial compliance statute? And if so, then how does that impact how we look at the particularity requirement in a recall petition?
So I think that you could read that as a substantial compliance requirement, although I think, in an ideal world, you'd have more indication about what that was supposed to mean. But I think the if you read that as substantial compliance, I don't think you can read that with respect to the 200 words, because I don't think you can kind of sort of fudge a direct word count in that way. So then I think you're left with, in effect, what the court did in Miners, which was to apply a sort of liberal construction. And I think the committee wants the court to add substantial compliance and liberal construction together to get a sort of double helping. But I think that the not substantially in the required form is consistent with a more liberal construction. But I don't think that a liberal construction or substantial compliance is met if you simply allow a level of vagueness that doesn't indicate to the reader why the alleged conduct creates a problem that should lead to the removal of this official. And it doesn't allow the official an adequate opportunity to respond in their own 200 words, because they have to try to explain stuff that's been left out of the original statement. So I think you can read that as substantial compliance, and you can find that to be consistent with liberal construction, but I don't think that changes the outcome, because what we have here is a lack of specificity. And because of where we are with my time, I'm going to go on and talk a little bit more about the specific allegations here that we haven't already talked about. So starting with the judicial appointment allegation, I think it's really important to think about whether the theories that the committee has offered can create a rule that has any meaning for the recall system generally. Their position essentially is, we have alleged that the governor violated the law, and That's good enough to get us a recall election, assuming we can get our signatures. But I don't think that it's plain that a violation of law necessarily should subject an official to recall.
But counsel, you're arguing in the abstract. The actual application in this regard says that he violated Alaska law by refusing to appoint. So I think you really should focus on the actual text here of what the committee submitted.
So, but I don't think that helps us. So the governor refused to appoint a judge within a specific timeline.
As
There's no
required by
allegation
law.
that he didn't appoint a judge, or that he didn't appoint a judge from the list of nominations that he was given, or that there was a vacancy, or that there was any impact. So what we have is the governor refused to meet a statutory deadline. Why is that a reason to remove him from office?
Perhaps because the governor is charged with applying the laws faithfully.
But so if the governor can be subject to recall every time anybody thinks that he's violated a law.
But that's not what we're talking about, really. We're talking specifically about the statutory requirement to appoint a judge within 45 days, which has been subject to some investigation and controversy going back to Governor Hickel. He ultimately did make his appointment within 45 days, and also Governor Murkowski, who ultimately did barely make the 45 days. But I mean, this is not something new to governors. Governors, with some frequency, chafe at the judicial selection process. But the statute requires appointment within 45 days.
But so the fact that the statute directs the governor to do something within 45 days. But I don't think you can say that has to be okay in this scenario only without understanding that you're creating a rule that whenever an official is accused of violating a law, that's going to be enough to subject them to recall. And I think if we look at the Constitutional Convention, the delegates there were clearly concerned about whether officials
Ms. Payton-Walsh,
would be...
you're at your 1 minute and 55-second mark.
Thank you. So if you look at the Constitutional Convention, they rejected an attempt to change a proposed ground, which was a conviction of a crime involving moral turpitude. One of the delegates wanted to strip out the involving moral turpitude and make conviction of any crime a recallable offense. And the convention rejected that. So I think the notion that we can have a rule that any violation of any civil statute should subject an official to recall, it cuts against what the convention decided, and it also creates a situation in which any statute, we talked about in our briefing various statutes that say that the governor shall issue a proclamation to commemorate a particular holiday. So are we going to have a system where the recall or an official can be recalled because they refused to issue a proclamation commemorating a particular holiday? That can't be what this process is for. And if it's not, then this allegation needs to do more than just say, here's a law, the governor broke it.
I'm hoping you can see the difference between that kind of a proclamation and something that is an actual statutory duty that, such as discussed in the first ground. But in any event, I'd like to know whether or not you think it's at all significant that the current position of the Department of Law is contrary to some of the specific positions it has taken in past decades.
So I think that both the court as an institution and the Department of Law as a legal agency evolves, its legal opinions evolve over time. And different lawyers look at different things and see them differently and make different arguments. The court has changed its mind. The Department of Law can change its mind. I don't think that the fact that somebody in the 1980s had a different view of this should control forevermore any position that the Department of Law can take. That's not how the law works. and it shouldn't be how government works. And I'm going to reserve the rest of my time, if I may.
Yes, thank you, Ms. Peyton-Walsh. Ms. Lindemuth?
Yes, thank you. If it may please the Court, Donna Lindemuth for Recall Dunleavy. With the 30 minutes, I obviously cannot cover everything. The issues are well briefed. My main goal is to answer the Court's questions this afternoon, and I will pause occasionally as we are telephonic in order to allow time for questions. I plan to spend half of my time on the proper interpretation of the grounds and the particularity requirement, and half discussing how those standards apply to the allegations in this case. The recall application clearly states valid grounds for recall. This is not one where there's mere policy disagreements at stake. There are 3 violations of law and a serious mistake not authorized by law that are the basis of the recall. The division, relying on Attorney General Clarkson's opinion, improperly denied certification of the application by changing the rules of the game and narrowly construing the grounds and the particularity requirement. Ignoring almost 30 years of precedent from the courts and prior attorneys general, this administration seeks to ratchet up the standards to thwart the voters' constitutional right to recall Governor Dunleavy. To do this, the division invites you to legislate from the bench in at least 3 areas. They ask you to add a harm requirement not found in the statute to all of the grounds. They ask you to add a mens rea or state of mind requirement in describing how the act meets the ground. And they ask you to require specific examples, a requirement that was previously part of the local government recall statute but was removed when the 200-word limitation was added. None of the division's proposals are based on the plain language of the statute, which is why the division argues liberal construction is irrelevant in this case. The division wants you to ignore or overturn the minor court's direction, deliberately construe the recall statute, as well as the statutory directive that substantial compliance is sufficient. That is the only path to rejecting the recall application. I want to first focus on liberal construction. The division's opening brief had no mention of liberal construction of the statute and no discussion of what constitutes substantial compliance. The division, in its reply, finally concedes liberal construction is mandated by minors, but argues it is irrelevant. And a close reading of the division brief shows it's actually arguing for strict construction of the statute, even if it doesn't use that term. And there are 2 primary arguments it makes, both of which are easily rejected. The first is that the Constitutional Convention debate shows that there are heightened standards intended by the delegates. No, the delegates punted the ground to the legislature to decide there was no direction or limitation on what those grounds had to be, and that argument was already considered and rejected by the minors' court. The division also argues that there's a due process right of the governor to his property interest in holding a seat that requires a stricter construction of the statute that favors the official. Again, this is an argument that minors rejected in footnote 7 of that decision. An official's interest in his office does not trump the voter's constitutional right to recall. Government's power comes from the people, and all officials serve subject to the people's right to recall. It's one of the basic checks and balances in our Constitution.
All right, I do have a question about this, though, Ms. Lindemuth. This is Justice Stowers. You know, I understand your liberal construction argument, but this is a recall for cause process. It's not a recall simply because people disagree with a particular official's policy calls, or they just may not be happy with the individual for general reasons. So at what point does the for-cause limitation or construction affect the liberal construction application that you're arguing for? I mean, surely your request to have the court apply a liberal application to this doesn't mean that the for-cause element disappears altogether, does it?
Justice Stowers, no, Your Honor, it doesn't disappear altogether. And this for-cause issue is something that the minors and the von Stauffenberg court struggled with themselves. And how they dealt with it was to add the legal sufficiency review in addition to the factual sufficiency review. And what that means is that the court held back in minors and applied it in von Stauffenberg that an official should not be recalled for the violation of non-existent laws. The legal sufficiency review ensures that an official cannot be recalled from your policy disagreements, but there's no need to strengthen the grounds or strictly construe the grounds or require additional showings of harm, because the legal sufficiency review ensures that the official cannot be recalled for legally exercising his or her discretion as an official. That's not something that's found in the statutes, but something that this court applied or required back in Minors and then was applied in von Stauffenberg to make sure that there actually, the grounds actually had cause to proceed with the recall.
This is Justice Moss, and I have a question about your interpretation of Minors. We did say there, and we said again in von Stauffenberg, that that the allegation of a violation of a non-existent law wouldn't be sufficient to allege grounds for recall. Is that really the only standard when we're talking about violation of a law as to whether the law exists or not, or should there be some non-triviality standard in addition to that the courts or the Division of Elections or both would apply? And do we need to determine, when presented with a case like this, whether the laws that are alleged to have been violated are important laws or unimportant laws?
Yeah, I think that that's something that is for the voters to decide, and that if there's a violation of law, that's sufficient. But it's also something that is at the fringes of the case that doesn't necessarily or isn't implicated by the questions that are before this court in this particular case. What's alleged here are all serious violations of law, or in the last instance, a serious mistake that's not authorized or within the discretion of the office holder. It's an interesting question, but it's not actually one that this court needs to answer in this particular case.
But it's one that we're interested in, so I'm going to pursue it a little bit. So, say you have a governor. We'll call the governor Joan Smith. Joan Smith gets Parks Highway for driving 80 miles an hour. Your argument is that violation of the law is sufficient to put the recall question before the voters, and your answer to Justice Mawson's triviality question is it's up to the voters to decide.
The way the courts have applied that standard, the von Stauffenberg standard, throughout the Superior Court cases that we have before show that the grounds actually have to be tied to the office holder's actions in office. And so that's something that Judge Gleeson discussed in her particular case. But again, so the examples are, illustrated by the cases that we've had so far. So in von Stauffenberg, executive sessions were allowed under the Open Meetings Act. There was no violation of law alleged in that particular case. In the Coghill case, there were political statements against opponents. That's something that he did in the context of his job, but it also wasn't something that the law doesn't allow him to do, is make political statements against opponents. Citizens for ethical government working as a veto contractor is something the law allowed. There wasn't the additional allegation of a bribe or some other illegal activity part of that allegation. And indeed, in the most recent Attorney General opinion, which dealt with Representative Holmes, recall effort against her was because she switched parties, and that was not allowed to go forward because that's a constitutionally protected act. It's something that the law specifically allows rather than a violation of law.
So let's talk about an example, another example where the Constitution specifically allows the governor to do something. Let's talk about line item vetoes. The Constitution specifically gives the governor explicitly and expressly the authority to line item veto a particular budget item. So let's say hypothetically the governor vetoed a couple $100,000 from the Alaska court system's appellate budget. And let's say the governor didn't express any particular reason for doing that. The governor just felt that that was an unnecessary appropriation. Is that conduct by the governor in exercising the constitutional authority that he has subject to recall?
Justice Stowers, a discretionary act can still be the basis of a recall if it was unlawfully done. And this is something that Supreme Courts in other cases and other states have grappled with. So the Colby-Webster case, the Washington Supreme Court held that a discretionary act can be a basis of recall if arbitrarily or unreasonably used, if there were untenable reasons or untenable grounds. The New Mexico Supreme Court in CAPS v. Board members said that it can't be a discretionary act unless there was an improper or corrupt motive. So there are limits on how discretionary acts can be the basis of a recall, and that's when they're illegally done or done in violation of law.
And under your theory, is it the voters at the recall election that decide whether it's arbitrary or improper?
Well, turning to the specific allegation here with the veto of the judiciary funding, it's alleged that it was done illegally and in violation of the separation of powers. And so that allegation is made, and for the voters to decide whether they agree with that or not.
Well, I have a question about that, counsel. Stowers is trying to get at, and that is on the legal sufficiency prong of how we would view a statement for recall. I mean, it's easy, say, looking at number one, when you're talking about violating Alaska law by refusing to appoint a judge in 45 days. That law is, set out pretty clear. We can all understand it, and we can understand the allegation that he refused it, to do it. The one about separation of powers is a lot more amorphous, if you will. Separation of powers is kind of, it's not a law. It is a doctrine, a constitutional import that allows us to interpret the constitutionality of actions, some things, and also allows us to determine, who in the various branches of government is entitled to do certain things. But how do we know? How can we say that even if Governor Dunleavy vetoed the line item veto of appellate court funds to attack the judiciary, how do we know that that's a violation of the separation of powers? Is it enough to say it might be? Do we have to decide that it is in order for this one to go forward? How does it work? What is our role in determining the legal sufficiency on that particular recall claim?
Thank you for your question, Justice Winfrey. I think that this court is to do the legal review and not allow the legal determinations to be made by the voters. And so if this court were to determine that there could never be a violation of law by the veto of court system funding, then I think this allegation would be insufficient. But if there are any particular facts that could be shown or any particular instances that such a veto could be illegal, then it's sufficient to go to the voters.
So, Ms. Lindemuth, I wanted to follow up on the separation of powers issue. This court said in Hornaday versus Rowland, which was a 1983 case, in order to invoke the doctrine of separation of powers, actions by two branches of government must be involved. And 16 Amjur 2nd Constitutional Law, 2nd edition 2020 says the doctrine of separation of powers prohibits one branch of government from exercising any power that is not explicitly bestowed by the Constitution or that is not essential to the exercise thereof. And I'm struggling to see how the judiciary had any role to play in the governor's line item veto of its budget. I don't even understand how the separation of powers doctrine fits here.
Thank you for your question, Justice Stowers. So the separation of powers doctrine is obviously a doctrine in our Constitution that it prohibits one branch of government from impinging on any of the other powers or other of the other branches of government. If one branch of government tries to control another branch of government, let's say by making it clear that there will be retribution to that branch of government's budget if they issue certain decisions that the executive branch disagrees with, then that is the executive trying to impinge or control the judiciary in a way that violates the separation of powers. I don't believe there has to be an act at the time of the judiciary. It's an act. It's the power of the judiciary that's being impinged.
Counsel, this is Justice Eastaugh. Are you cases in which the court has declined to rule on particular issues on the grounds it might infringe on the separation of powers of a different branch of government, usually the legislature.
Sure. This court has in many instances said that there's political questions that the legislature is going to make, and so, the court has exercised restraint and not impinging on the legislature's powers by legislating from the bench, if you will, when it's something that the legislature should take instead of the judiciary. So I'm not sure where I am on with time, but I think I should turn to the specific allegations in the case.
14 minutes and 30 seconds left.
Okay. The four factual allegations in this case, and that the allegation, the statement of grounds, is that they each meet the three grounds: fitness, incompetence, and now the application has to be certified if one allegation survives on just one ground. And I want to start with the fourth allegation because the arguments the division makes are very similar there. Now, the statement of grounds is at excerpt page 1, and I think it's helpful to have that in front of you while we talk about the statement. The first is that the government to appoint a judge to the Commerce Superior Court within 45 days of receiving nomination. The division concedes that this clearly led to a violation of law, but the division characterizes this as a technical violation, arguing that harm had to be alleged or at least apparent from the violation. Judicial appointment is a core function of the governor, and the Constitution requires the governor to appoint from the Judicial Council a list of nominees. The legislature set a deadline by which the governor needs to act. And this is not a case where the governor simply missed a deadline due to inadvertence. The recall sponsors have alleged intentional refusal to appoint. The division ignored this, and this is a factual allegation that must be accepted as true. The refusal to appoint is far from inconsequential. It risks serious damage to another branch of government, the judiciary, as qualified applicants very well may not apply since the governor is politicizing the appointment process. This new requirement of alleging harm is not. The Attorney General in that decision actually argued that the governor was free to ignore deadlines set by the legislature. The division has added this new harm requirement in briefing. But again, this court has already rejected the argument that the Constitutional Convention delegates dictated heightened requirements as to cause or required harm to be shown, and instead left the entire issue to the legislature to deal with in the statute. Now, Judge Savelle in the Coghill case held that not knowing the elections code was grounds for recall, and no harm was required to be alleged or shown in that particular case. That statement of grounds is attached to page 3 of the division's appendix to their opening brief. And it wasn't even alleged in that particular case that Coghill was the lieutenant governor or that he was in charge of elections. Now, again, this administration wishes we had a different statutory scheme, one like Virginia, that actually requires harm to be alleged. And that particular code actually requires that there be a material adverse effect upon the conduct in office. That's something that's not found in our statutory scheme, and liberal construction under minors means that this court cannot add that requirement to our law. The recall sponsors have alleged a serious violation of law that is legally sufficient. Again, the governor is responsible for the faithful execution of our laws under our Constitution. His failure to obey the law shows lack of fitness and neglect of duties, and he's incompetent if he didn't understand this obligation or if he understood and chose not to comply. The fourth allegation is that Governor Dunleavy acted incompetently when he mistakenly vetoed approximately $18 million more than he told the legislature in official communications he intended to strike. Uncorrected, the error would cause the state to lose over $40 million in additional federal Medicaid funds.
What if he had just changed his mind? What if he had communicated to the legislature that he was going to permit this $18 million, but then after he told the legislature that, He thought about it again. He might have gotten some additional information about the state budget as a whole, and he changes his mind. He decides to veto $18 million more than he told the legislature he was originally thinking. Does the governor have the authority to do that under the Constitution?
Justice Stowers, the governor obviously has the ability to change his mind on any line item veto. But what's alleged here is that he made a mistake, and it actually, in fact, he admits that he made a mistake and that he told the legislature he vetoed more than he intended. And then the legislature fixed it. The legislature actually did fix it in this particular case after the recall application was submitted and was pending. But the fact that the legislature corrected the mistake later down the line doesn't mean that the governor is off scot-free and that this can't be grounds for a recall of the governor. Because making a serious mistake like this is not something that the law authorizes him to do or is within his discretion.
Is there any room for the court to apply a harmless error standard here? Again, Justice Howard, the harmless error standard is not in our statutes, and that's not something that's... Neither is the liberal construction doctrine. Well, liberal construction is a rule that the court applies to different statutes to determine whether it's going to be liberally construed or strictly construed. And the minors court many years ago decided that the recall statute should be liberally construed. But that is consistent with the legislature's directive in the statutes to allow substantial compliance with recall sponsors putting forth an application.
Ms. Lindemuth, so any mistake is going to subject an elected official to potential recall?
Your Honor, Justice Carney, how we've briefed this is that any serious mistake that's outside of the discretion granted the office holder. Now, if there's a missed deadline of a day or two that there's inadvertence or the like, that is within the office holder's regular daily activity. We're not submitting that's grounds for recall, but that's not what we have here. And that's again a question at the fringes where this court need not decide every single kind of case that may come forward in the future. What we've alleged here. But that sounds a lot
like a different way to phrase the Stowers question about harmless error. It sounds like the inverse. It has to be harmful error.
Justice Carney, we're not saying that it has to be harmful error or that it has to be that there has to be or an uncorrected error. What we're saying is it has to be a serious mistake that's outside the discretion allowed by law, because that's the standard that the von Stauffenberg court set in addressing legal sufficiency of an allegation. Now, returning to my argument, the only argument the division makes here on the Medicaid veto is that one mistake can't constitute grounds. And in the reply, the division appears to back off this argument and concedes that one mistake may be sufficient, but more explanation is needed. And again, they return to the harm requirement that harm needed to be alleged. And again, this is not in statute, and this court cannot add that additional requirement as it must liberally construe the statute. This ground is legally sufficient. This is a serious mistake of $58 million, $18 million in state funds, and $40 million in federal funds. That's not allowed by law. It's not legally within the discretion given to the governor by law. The voters can find it meets all three grounds. The mistake can be a measure of competency, and neglect of duties and lack of fitness can be shown because the governor has a duty to understand the budgeting process. And if he lacks the intelligence or lacks the carefulness to comply with the budgeting process, that can be neglect of duties. Now, the final two.
Did the committee waive, with respect to this allegation number 4, did it waive neglect and lack of fitness by specifically narrowing the charge to incompetence?
Justice Sowers, I don't believe that we did. That's not the intention of how we've drafted this. If you look at the top line, it says neglect of duties and incompetence and or lack actions, and there's 4 bullet points.
Right, I see that. That was the reason I asked the question, because perhaps if it's permissible, to argue these things collectively or in the alternative with respect to 1, 2, and 3, but then you get to number 4 and you very narrowly framed the allegation on the grounds of incompetence. And I'm wondering, by doing that, aren't you advising us, or the voters for that matter, that you're not alleging neglect or lack of fitness with respect to number 4?
That's not how I read it. I mean, obviously a voter could read it that way, and I don't think it makes it legally insufficient to do that. But I read it that the incompetence of making a mistake can be a neglect of duty and or show lack of fitness for the reasons I just stated. Now, turning to the last 2 allegations, the division does challenge the factual particularity of these 2. The second bullet point, Governor Dunleavy violated Alaska law and the Constitution and misused state funds by unlawfully and without proper disclosure, authorizing and allowing the use of state funds for partisan purposes to purchase electronic advertisements and direct mailers making partisan statements about political opponents and supporters. Now, the division argues that we needed to describe the ads so that the division of voters can determine whether they really are partisan or whether they were instead for public purposes. The factual allegation that they were for partisan purposes is a factual allegation that must be assumed to be true when evaluating the sufficiency of the allegation. There's a legal definition of partisan purposes in 3952.120b6 that excludes state funds spent for a public purpose from the very definition of partisan purposes. Spending state funds for partisan purposes is a clear violation of the Ethics Act, and as well as the campaign finance laws, and it's also in our Constitution. State funds can only be spent for public purposes. This is not the von Stauffenberg case or the Cog-Hill case where the legal sufficiency issue. What was alleged in the case was legal behavior. What is alleged here is illegal behavior because there's no situation where state funds can be used for partisan purposes. It's always illegal. Now, specific examples have never been required as part of state official recall statute, and this requirement of specific examples was removed by legislature from the local official recall statute. The 200-word limit was added. Again, given that there's 200 words, there's only so much that can be accomplished. This court should reject the invitation to legislate from the bench to add this requirement to our statute. I want to spend a couple of minutes on the judicial veto allegation. Again, the allegation is that the Governor Dunleavy violated separation of powers by improperly using the line-item veto to attack the judiciary and rule of law. The division does not defend the ability of the governor to veto court system funding based on a disagreement with a decision of the court. The division argues only factual particularity, but this allegation is not impermissibly vague, and the governor can respond. There's multiple factual allegations here. 1, that it's a line-item veto. 2, that it attacked the judiciary, that involves the court system. 3, it was an attack on the rule of law. And 4, that it violated separation of powers in our Constitution.
You're at 2 minutes, Ms. Lindemuth.
Thank you. And again, it referenced the OMB change record detail for appellate courts. The Attorney General's opinion conceded that he and therefore the governor knew exactly what veto was at issue. That's excerpt 328. Now, this recall effort is not based on mere policy disagreements. The recall sponsors have alleged with particularity 3 serious violations of law and a serious mistake not authorized by law. Recall is meaningful in Alaska because of the legal sufficiency review requires grounds for recall be based on acts outside the official's legal discretion granted by law. Additional hurdles argued by the division are not needed. This is already, moreover, the voters act as gatekeepers as well. Recall under the Alaska statutes is difficult. It takes 10% of the voters to apply for certification of a petition, 25% of the voters to sign the petition in order to have an election, and then there needs to be 50% plus 1 to vote in favor of recall in order for the governor to be recalled. This is already a difficult process, and this administration seeks to make it an impossible task by adding artificial technical hurdles that this court warns should not be imposed by the judiciary. If this administration wants to change how recall is conducted in Alaska to make it more protective of officials, it can seek a legislative change. Recall Dunleavy asks this court to affirm the judgment of the Superior Court.
Thank you, Ms. Lindemuth. Madam Clerk, how much time does Ms. Peyton Walsh have left? 5 minutes. Ms. Payton-Walsh, are you ready?
Yes, Your Honor.
You may begin.
So I want to hit a few things that Ms. Lindemuth said as quickly as I can, and I want to address first of all her sort of generalized argument with respect to the first paragraph about the judicial appointment and the fourth paragraph about the Medicaid veto. And her position essentially is we're demanding an extra statutory requirement or statutory showing of harm that isn't in the statute. That is not the case at all. That would be true if the grounds for recall were that an official had made a mistake or violated a law. But that's not what the grounds are. The grounds are lack of fitness, neglected duty, and incompetence. What is the difference between violating a law and lack of fitness? Maybe that's a showing of harm or some consequence that demonstrates that this official should not be holding office. The harm thing is it's not an add-on. The harm is the difference between making a mistake and being incompetent. On Judge Cabell's treatment of Lieutenant Governor Coghill doesn't undermine that. What Judge Cabell did was to say Lieutenant Governor Coghill requires a certain body of knowledge to do his job. That's a different way of showing incompetence. And I think as we pointed out in our briefing, you can be incompetent because you lack the fundamental knowledge that you need, or you can be incompetent because you make mistakes that demonstrate you can't do your job. But those two things require more than just a mistake, and some sort of elaboration or explanation of how we get from the mistake to incompetence is baked into the statutory ground. Otherwise, it's the committee that's trying to rewrite the statute, I guess, is what I'm trying to say.
But Ms. Payton-Walsh, isn't the magnitude of the mistake fair game to consider?
Well, I think it is, and I think you could say that an official had made a mistake that was so devastating that it demonstrated that they were incompetent. But that's not what we have here. What we have here is a mistake that was fixed. According to the allegation itself, we have a mistake that was fixed. And it's not at all clear why a corrected error is sufficient to demonstrate that an official is so incompetent that they shouldn't be allowed to remain in office. Secondly, I want to address something that the committee has done repeatedly, which is to try to take what is actually a legal conclusion and pretend that it's a factual statement. So, the court talked a lot earlier about the powers is a legal doctrine, but whether something violates the separation of powers is a legal conclusion.
Ma'am, you're at 1 minute and 55.
Right. It's not a factual statement that can substitute for a lot of additional factual statements. The same is true of the committee's attempt to turn their claim that the governor paid for advertisements for partisan purposes. I mean, Ms. Lindemuth pointed out herself that this is a term that is defined in statute, and the fact that it's defined.
Back on the separation of powers, then maybe I'll ask you the same question I asked Ms. Lindemuth. What do we do as the court, looking at item number 3 and looking at the legal sufficiency of the allegation that something violated separation of powers? What are we supposed to do? Are we supposed to make a decision that it did or it didn't? It could or it couldn't? What is it that we're supposed to decide?
So, Your Honor, I think what you do is you look at the facts alleged in the paragraph, and then you can see that there's no basis to make any sort of separation of powers argument. What we have is that the governor used his line item veto to cut the appellate court budget. That's wrapping the reference in. That's all you have. That is clearly within the governor's authority. They have not alleged any of this other stuff that they want to say is what makes it separation of powers. They haven't said any of that stuff. It's not in the allegation. It's not in the statement.
I think
it's not there.
Counsel, this is Justice Eastoe. I think it is in the allegation. Whether it's sufficient, I don't know. But it asserts that he did this to, which would mean in this context in order to, or for the purpose of, attacking the judiciary and the rule of law. So I think your most recent argument ignores those words, which are squarely in the provision.
So I think that the problem there, Your Honor, I think is that the phrase "to attack the judiciary," I mean, beyond assaulting a judge in a parking lot, right? What does it mean to attack the judiciary? I don't think that communicates factual information to a reader who doesn't know what this is about. If you know what that allegation is about,
would the committee have been required then to quote what the governor said for the reason behind his veto of the fund?
Well, I don't think
how does that fit into 200 words?
I don't think that they needed to quote his language. I think that they could have paraphrased it, and in fact they did in their briefing in far fewer than 200 words. So if that was going to be, this isn't a we don't have enough words problem. They chose not to put those facts in, and one can't help thinking they probably did that because they didn't think that everybody would agree with them about the governor's veto. You know, they're looking at voters, and voters are going to have different perspectives on these issues. So I don't think that the committee gets to essentially hide. They're not explaining what happened so that a reader can understand exactly what the governor did and why he did it. And that's the problem with all of these allegations. With number 2 and number 3, there's really no way.
Ms. Peyton-Walsh, I beg your pardon. You're a minute and 30 over. Let me ask my colleagues if anyone has any additional questions for Ms. Peyton-Walsh. Not hearing any. Thank you, Ms. Peyton-Walsh. And I want to thank on behalf of the court all of the attorneys who did excellent work in briefing and arguing this case. Take the matter under advisement. We will issue a written decision at a later date. And now we will be adjourned for the day.
Thank you.